Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. So let's get into it. We have the comments right here, and these are comments that you have left on our YouTube channel. So I'm gonna read them and I'm gonna comment back about them and answer your questions. So the first question, someone asks that they have a truck accident case and they have an offer of $50,000 and their injury is that they've had some injections. So what I would say to a case like that is it really depends on where you are, but it sounds a little light to me. Like I've settled truck accident crashes with injections for even 150 or more, 200,000. So it could be a little light. But you're not really giving me enough information. It's always better to text me, 347-566-9595. And when you do text me, just include your name, brief facts of what happened, your injury information, and a good time for a call. And then we could schedule a call and get the call done. And it's always free, it's always confidential, and it's just a chat where we could discuss everything in depth and I could tell you, because I don't want to give you the wrong information, and by me trying to answer like a few words on a public social media channel, it's really going to be the wrong information. I'm not going to be able to. No one, not just me, and no one can really, tell you what a case is going to be worth based on that. Here's a question. Notarant says, okay, Mr. Frecht, if a person switches lawyers and the courts have to get involved, is the case now a case within a case? For example, a personal injury case, but you have to go to court to get the paperwork from the previous lawyer. No, so it wouldn't be a case within a case. It would just be a motion on the underlying case. So you already have the case, you have a lawyer, but now you want to fire that lawyer and you want to hire a new lawyer, hopefully a better lawyer, a trial lawyer. So if the old lawyer is giving you any trouble not turning over the file, it's as easy as filing a motion with the court. And as the exhibit to the motion, you just include your signature where you fired that lawyer, then removing all authority from them, right? Just like when you fire an employee at work, they get the box and they put all their stuff in it, their plant and their photo, whatever they have, and they go away. They're not there anymore. They don't have any power to do anything in that company because they've been terminated. So the same thing with lawyers. Once you fired them, they can't hold your file hostage. If they are, the judge will just sanction them and the judge will order them to turn the file over. And if they still don't, what the judge will then do is probably say that they are not entitled to a legal fee in this case, right? Because remember, if they did some work, they can have a percentage of the legal fee. And the percentage of the legal fee is a third total, usually it could be 40% in some states total. That means you as the client always get the 70%, the lion's share, that's your piece of the pie. But then that 30% gets shared by the attorneys that are in the case. So if you have one attorney, they get the 30% all to themselves. Like if it's $1 million, they get $300,000. But if you have two attorneys, they just share that $300,000. They share the 30%. If you have 3, 4, 10, 100, they just share the 30%. Doesn't really affect you. You still get your 70%. But in order to effectuate the change, you may have to make a motion. But literally, that's very rare. That you have to make a motion, maybe 1 out of 100 times. And even if you do, it'll just take a week or two. Usually the lawyers don't really, hold the file hostage because they know that by doing that, they might not be entitled to a legal fee and they're hurting themselves really. Here's the next question. Oh, hey, nice info, thanks. Hey, we are 13 days away from statute, ha ha ha. Know any malpractice lawyers? Let me know if so. Yeah, so this is a person that we've been communicating with for a while. He's been like a regular viewer of our channel, and I know a little bit about his case. And unfortunately, he hired a lawyer, but now he's just 13 days away from statute of limitations, meaning if you don't file the lawsuit, the case disappears, and this lawyer is still not filing a lawsuit. It's a real red flag, and I think I consulted with him. I offer him to, give me a call, just text me, 347-566-9595, because it sounds like you don't have a trial lawyer, so you probably should get a trial lawyer in your city as soon as possible, because that person will then help you and get you maximum justice, full justice, because obviously whoever you have now is just like not even serious, not even professional. You don't let a case go 13 days into a statute of limitations, then it'll be forever barred. And now you're looking for a lawyer to sue your lawyer. Why get yourself into this mess? Why do that to yourself? Just get a good lawyer right away. It's really simple. I said, just text me 347-566-9595. Let's get you a real trial lawyer ASAP. I don't like to see that happen to clients, especially nice people like this. It's terrible. Jay Smitty says, what are the average emotional trauma settlements from something like this? And he's referring to my short video, Can a Witness to an Accident Get Money? And I was talking about the zone of danger. If you have a loved one and you see the loved one get into, say, a car crash, and what could the settlement be for the zone of danger? It could be, a few $100,000. I remember one case many, many years ago. This was more than 10 years ago, but she was walking with her mom, and her mom got hit by a car, and she was there, and she saw her mom, and her mom ended up passing away. And I think the settlement was something like the full policy. It was like $350,000, something like that, or $400,000. But it was a significant settlement. So that's usually at least a few $100,000. It could even be into the millions, because that's a real serious case. I mean, that's horrific, and nobody wants to see somebody like a family member or somebody you love get into an accident like that and be in that zone of danger and just have that emotional trauma, and it's horrific. After falling in a hallway of a Bronx residential building, a spill which had been reported days ago was not cleaned up nor a sign up. Someone fell and ended up hurting her neck. After a year of physical therapy and pain management, had a cervical spinal fusion. What would you consider a fair settlement? 40-year-old with a college degree currently working. Yeah, I mean, I would say something like that, probably, it's hard to say exactly, but I would say something like that could be a very significant settlement. It could even be into the millions and millions of dollars. Like, we just had a Bronx trial with a lumbar fusion. We settled it for 2.2. We had one last year with a cervical fusion. We settled it for 3.5 million. So something along those lines, I would say anywhere from 2 to 5 million. It could be even more than that. So I think it's important really to examine the underlying case, really, look into the case, how much insurance is there, what are the injuries, how has it been a life-changing injury, what are the facts and the liability, because you don't want to just, short shrift it and say it's worth X without doing a deep dive. So I offer, text me 347-566-9595. I'm happy to chat and happy to help with that. And here's a question from David. He says, sir, could you do a video on ADR in New York State personal injury lawsuits and what they are and what happens at one and your thoughts on them? Appreciate. Do you think they're okay? Yeah, so actually, we did that actually, where it's gonna come out soon. We just did that. So we talked about alternative dispute resolution, which includes arbitrations and mediations. But to answer your question briefly, I do like mediations in some contexts, especially when the defendants put up a good faith offer of, close or near what you're looking to get in the case. That's a prerequisite, meaning don't just go to a mediation because the defendants say, let's go to a mediation, we agreed to a mediation. That's a trick. They can bring you to the mediation table and then just offer you a lowball settlement and just get you upset, and then you just end up leaving and you end up paying thousands of dollars for the mediation, and it breeds this kind of discontent and acrimony between the attorney and their client, because the client's going to be like, well, wait a minute, I thought my case was going to settle for $1 million. Why did you bring me here? And the lawyer's like, well, I don't know, they agreed to a mediation, I thought I was going to come. And they do that on purpose to screw you over. So don't agree to that. Arbitrations I don't like at all, because the judge just decides the case. So if the judge is conservative and thinks the case is worth $15,000, well, then you're stuck with $15,000. You can't do anything. So why do that to yourself? Just go to a jury trial. Jury trials are much, much better. They take a little longer, but you're going to get much, much more money. Sometimes 10x or 100x. So I don't like arbitrations unless it's a real small case and you're trying to get rid of it. Mediations, like I said, they can be useful, but you need a good faith offer. Oh, here's a question from Brandy. I got rear-ended by an 18-wheeler about a year ago. He lied and said I jumped in front of him, avoiding hitting another car. So my car is still wrecked in the back. I refused to put that on my insurance. a lawsuit has been filed, but the 18-wheeler driver did get a ticket, and now I guess he's trying to fight it because I'm a witness in his case. Yeah, so the way to avoid that, now if you didn't jump in front of him, meaning change lanes in front of him suddenly, because 18-wheelers, you have the tractor and you have the trailer, and they're long, they're like 50 foot or more. So, they can't stop on a dime like a Ferrari, right? They take time to stop. So motorists have to be careful. You can't cut off an 18-wheeler, nor would you want to, because they're 100,000 pounds, many, many tons of force, and they can crush you and you can get really, really hurt. But the way to avoid that, if he's saying you did that and that's not what happened, you could ask for any kind of dash cam footage. You can ask for the black box, the electronic data control module, which they have in the car, and that'll show the speed 1 second before the impact. It'll show everything, right? So you could get that even like 10 seconds before, 3 seconds before, 1 second before. You have to get that information, the electronic control module, and then you have to send it to an expert, and then the expert will review the data and give you a report. So it might cost a little bit of money, but that could prove very, very vital, because everything is going to be in that, the speed, all the information. So that way you have all that information. So if it proves that the truck driver is lying, then it's even more powerful, because he's saying this happened, and if that didn't happen, now you know, hey, well, he's lying to avoid a lawsuit. So it'll make your case even that much more valuable. So that might be a good thing for you to do. Anjanya says, I wish you were my lawyer. Lawyers here won't call, never explain or help, do not seem to be focused on us. Want to move to New York, LOL. Oh, thank you so much. Thank you for saying that. Yeah, I mean, I wish I could help, but I could possibly help you, because I can't obviously do cases myself everywhere. But one thing that I've been doing for people is giving a consultation, answering your questions. And then if you need a trial lawyer in your city, I actually have a curated list of the best trial lawyers, and it's vetted, meaning these are people that have actually gone to jury verdicts, have gotten $1 million results, and they're independent. Like, I get the results from the court system, from the jury verdict reporter, from Westlaw, from LexisNexis. So they're independent sources that verify, hey, these are actual lawyers that go to court, they're trial lawyers, and they get $1 million results. And those are the lawyers that I then recommend to you. So that way you avoid getting somebody who puts on their website, oh, I got a $10 million verdict, but it's not really even true. And when you do a verdict search on them, they got like a $8,000 verdict, they got zero. And you don't want that. So I'm happy to do that for you. Just text me. Pamela Brandon says, I wonder how much this attorney was awarded for her pain and suffering. It's disgusting. Responding to a video breaking down high stakes fusion cases, verdicts, and settlements 2023. And then she also had another comment where she said, I don't get why these attorneys feel like they worked for almost half of the folks' settlement when filing paperwork. So I guess they're saying that attorneys shouldn't get awarded money because, I don't know why, because they don't like attorneys. It's like, okay, well, if a doctor does something like a brain surgery, right? And then that saves a person's life, do you say, that's disgusting, you did the brain surgery, you touched the brain, I hate doctors, why are you getting $100,000 for that surgery? No, right? I mean, you figure that's their job. They're a brain surgeon. They did the brain surgery. Sometimes they do the brain surgery and they don't save the patient's life. The patient dies, or they still get paid for the surgery. And nobody says it's disgusting, but there's some reason that people find that attorneys, right, are disgusting. And it goes to this ambulance chasing idea, right? That, oh, you're an ambulance chaser. You're chasing an ambulance because, when they get to the hospital, you want them to sign with you, and then you want to take a piece of their money. And sure, I agree, that is disgusting if that's what's actually happening, right? If a lawyer is just chasing an ambulance and then a person is really hurt and then they don't do any work and they just settle the case and then they take a third of the money, like $1 million settlement, they get $300,000 and they haven't done anything, that is disgusting. That shouldn't be allowed. But that's not really what happens, because the insurance companies don't want to pay fair settlements. So you have to file a lawsuit. You have to go into discovery. You have to do a lot of documents. You have to request for production and get documents. You have to do requests for admissions. You have to know the CPLR, the Civil Practice Laws and Rules, or the Federal Rules of Civil Procedure. It's very, very, litigation, a lot of litigation, a lot of work. It's crazy. And you could be litigating a case for like 5 years. And it's just an inordinate amount of work. Some of these red wells, they're like this big, and then you got like not one of them, but you have like 5 of them. And then at the end of the case, yeah, you get paid a third, but you're also risking it, right? Because you could be spending money on a doctor to come to trial and charge you 20 grand to testify, and you're paying that out of your own money. So as a lawyer, you could be fronting 100,000 out of your own money. And what if the jury says, you know what, we believe it's a defense verdict. You just lose that money. So you're taking a huge risk as a lawyer. So actually, in some ways, being a trial lawyer, it's actually much, much more vulnerable, right? And more risky than a doctor. Because that brain surgeon, okay, he's in the operating room, but he's not taking any risk. There's no way, whether the patient lives or dies. I mean, obviously he doesn't want the patient to die. He wants to do his best. He's going to get paid. And he's not risking any of his own personal money. But as a trial lawyer, like in that case that I settled last August, I risked over $120,000. So if that verdict came in and they said, you know what, yeah, we find that the defendant was negligent, but we don't think that their negligence was a substantial factor in causing the injury. Well, now you're out, right? The whole case is over. It doesn't matter because you haven't proven liability. You have to prove negligence and causation. You haven't proven causation, you get zero. And so then that 120,000 is gone, right? And it's like personal money. So it's a lot of risk. And I'm sure in other cases, lawyers have risked more, maybe even $1 million that they've put into a case, or more than $1 million. So I don't know. I think that whole thing is an insurance company, scheme. It's almost like a media campaign by the insurance companies to get you to believe that lawyers are all ambulance chasers, lawyers are all disgusting. But I'm sorry that you fell prey to that. You should use your own reasoning, use your own mind, not listen to the media and the insurance company spin that they want you to believe, because it's just not true. Marcus says, do you think me losing my sense of smell and taste from a car accident and getting the maximum payout of $250,000 was worth it? I feel I should have been paid more, and I'm curious your thoughts. Yeah, so I mean, it's never worth it, right? Nobody ever wants to get hurt, but if it happened already, you might as well get, full justice, maximum justice, which is the most you can get in that terrible situation of what it is. So kind of is what it is, but you just try to, so I don't know. I'd have to, if that's the maximum payout, if it was a 250 policy and there was no uninsured motorist, there were no other avenues, there was no excess or umbrella, if all that was checked, basically you check all the different avenues of possibility where you can get money. If all of those are closed off, saying you can't do this, you can't do this, you can't do this, and all you have is the 250 and they paid you the 250, then yeah, then of course it's good because that's all there is. So, but just so you understand, I mean, of course your health is priceless. That's the most important thing. So it's never worth it. That's actually what the defendants sometimes say. They kind of make you seem like you're trying to get a payday or win the lawsuit lottery, but it's not about that. You'd rather have your health. If it was a trade, you'd always take your health. You'd never want money. But sometimes these things happen. People are unsafe, they crash into you, and then you have these life-changing injuries like losing your sense of smell and taste. That's terrible. That's probably a type of brain injury because that's usually associated with a brain injury. Here's a question. A friend of mine received an injury on the job. A light hi-hat swung out of a ceiling and hit him in the face, causing him to receive stitches to his eyebrow. He was asked by the company not to file an accident report because they did not want to lose a potential job. I believe he has seen a specialist because he was having issues with the injured eye. He was recently laid off after the company lost the bid on the potential job. I was also injured on the job twice with this company, but was asked not to file a report because they were afraid there were too many accidents on the job in such a short amount of time. Unfortunately, I only have the word of the individuals who were present when I was injured. Yeah, unfortunately, that's common. A lot of these job sites, especially in New York City, that's what happens, right? And it's all like intertwined because the insurance companies sometimes say they don't want to pay on these claims, especially for construction, because the construction law really favors the worker. So if it's gravity related, for example, if something falls and hits a worker, or if a worker falls from a height, like a ladder or scaffold or platform, falls from a height due to gravity, that's going to be the fault of the general contractor and the owner. That's the labor law. There's a section 240, and that's strict liability, meaning all you have to prove are damages. You already won on summary judgment because it's gravity related and they didn't offer you the protection. Because you fell, well, that means they didn't offer you the protection, because if they would have offered you the proper protection, then you would not have fallen, right? So it's very, very strict liability. So in that sense, it's great for the worker, but then the tit for tat is when you flip it around, the insurance premiums are high and these companies are afraid they're not going to be able to, afford insurance. And then when they do afford insurance, then they don't want to report actual incidents that happen because they think, oh, the insurance company is going to think we have too many, we're not safe, and then they're going to cancel our premiums, cancel our insurance, or it's going to cost so much we're not going to be able to survive. And usually it's not an issue, but I guess in this case it was. So in order for you to bring a case, because all you have are the word of the other individuals, I would say, if you can get photos, go to the hospital from the scene, that's always good. Have friends or coworkers sign statements and give you copies of statements, notarized statements. You could even take videos of people, right, giving you a statement, like a 30-second video, and the person is telling you what happened, and you save that as a video statement. That's all good to have to prove up the case, because later they might say, well, this didn't even happen, right? And how are you going to prove that it did unless you have this evidence? So it's always good to get the evidence as soon as possible. So I hope that's helpful, but good luck to you. That sounds like a good case. We've actually been handling a few of these construction cases for workers, so I think they're still very good cases. Okay, everyone, thank you for joining us. This was Last Week Tonight, where we answer your questions and we talk about your comments. If you have a comment, just leave it in our channel and we'll answer your question on the next episode. Just include a little bit about your question, or if you have a case, you could tell us briefly what the facts are, just enough so we could see it happening, almost like we're watching it on the TV screen. And then tell me a little bit about your injuries, or if you don't know what your injuries are, then a little bit about your complaints or symptoms, and then we're able to give you as much feedback as we can. But in order for us to give you feedback, we ask that your question be a little bit more specific, or your comment be a little bit more specific. And if you want any other videos, just let us know what topics you want the videos about, whether it's construction accidents, explosions, fires, brain injuries, any type of case like a truck accident, car accident, slip and fall. We're happy to let you know and do videos about anything you're interested in. So please like and subscribe to our channel. Let us know what questions you have. Our goal is helping serious injury victims and families, and we are here for you. All the best.